Thank you all for joining us today. My name is Dustin Saldarriaga, and I'm an associate at Scott Legal PC. Today, we're going to spend some time talking about the E-2 visa requirements, and we're going to answer some of the top questions that we get when preparing an E-2 visa file. A few things before we get started. Some of you may know that our firm was actually founded on an E-2 visa 10 years ago. Our founder, Ian Scott, is currently in the US on an E-2 visa, so he knows exactly what many of you and our E-2 visa clients are going through. He's actually renewed his E-2 visa twice at this point, so has a vast amount of experience, personal experience, navigating the process that really does translate into how we approach visa applications for our clients. Our firm is a full-service immigration firm, so in addition to handling E-2 visas and business visas, we do handle family immigration as well as humanitarian immigration issues. We have processed literally hundreds of E-2 visas, and our firm does focus on E-2 visa cases that are considered to be particularly what we call risky, oftentimes due to a low investment amount or for some other reason. So if you are thinking about an E-2 visa, but have questions about certain aspects of it that you think might be obstacles for you, we do encourage you to reach out and talk with us. We'll continue this webinar, which is part of a series, by doing at least 2 webinars a month. We do those on a variety of topics. And at the end of this webinar, we'll send you all a few things. We'll send you an E-2 visa guide. This is a comprehensive guide that walks through all of the E-2 requirements. We'll also send you a link where you can sign up for additional webinars coming up. And please do note that this webinar is being recorded, so you'll be able to view the recording on our YouTube channel. And I encourage you all to visit our YouTube channel because we post our past webinars as well as a variety of shorter videos on a range of immigration topics. And finally, the email you'll receive after this webinar we'll have a link where you can set up a consultation with our firm if you'd like to talk about your specific circumstances. We're very fortunate to have Kelly Legrand-Wiener, who is our firm's managing attorney, with us today. She and I will both be answering questions about the E-2 visa. If you have any questions, please do share those through Zoom by using either the chat function or the Q&A function. We will be actively monitoring those questions. So without further ado, I will pass it off to Kelly to get us started.
Thank you, Dustin. Perfect. So as Dustin said, our firm processes E-2 visas primarily, in the riskier category. But let's get started just by talking about kind of the basics of the E-2 visa. And so Dustin, if you could share with us who can apply for an E-2 visa?
Absolutely. So the E-2 visa is a treaty visa. And what that means is that the United States needs to have a treaty with the country that the applicant is a national of. So fortunately, there are many countries that are on the list of E-2 treaty countries. And you can find that list by Googling E-2 treaty countries. And you'll see that they really do span the globe, from Latin America, Canada, Mexico, Europe, Australia, New Zealand, Asia, so really around the globe. So check to see if you're on the list. Some countries that are not on the list are China and India, Brazil, South Africa. So there are some quite populous countries that are not on the list. Fortunately, you only need the nationality of an E-2 treaty country. So that means if you were born in a country that is not on the list of E-2 treaty countries, such as India, you can apply for citizenship in another country that is on the list of E-2 treaty countries, such as Grenada. And once you get the passport from an E-2 treaty country, you're eligible to apply for the visa. So really, it is a visa that's broadly available to many people. And we do work with clients who are not born with E-2 treaty nationality, but who acquire it through citizenship by investment.
Perfect. Thank you. And is the list fixed? Are there ever kind of additions or subtractions from the list of treaty countries?
There are. So some recent additions, Israel, New Zealand, the list does change. So it's worth checking it just to make sure that you have the most updated version.
Perfect, thank you. So let's talk a little bit now about kind of what an E-2 visa is. Maybe if you could go through for us, what are the key requirements to qualify for an E-2 visa?
Sure. So in addition to nationality, which is a threshold requirement, you do need to, speaking about the E-2 investor visa, you need to own at least 50% of the E-2 business. The E-2 business needs to be some kind of a legal entity in the US. So many of our clients will form a limited liability company, an LLC, or even a traditional corporation in the United States, which will form their E-2 company. They need to own at least 50% of that company, and they need to be in a position to develop and direct that company. So that means not only ownership, but also they should have some background that qualifies them, and that a consular officer would be convinced that they, as an applicant, are qualified to run the business. They also need to invest in the business. And this is a requirement we'll talk about more in this presentation. What the law says is that they need to invest a substantial amount into the business. That depends on the type of business. But in general, we tend to want to see an investment amount of at least $100,000 into the business. And that money needs to actually be committed to the business, meaning actually spent, not just transferred to a business bank account. The business does need to support not just the investor and their family, but also US workers. And that needs to occur within 5 years of the business being operational. So what we would generally say is the business should employ at least 3 full-time equivalent US workers within 5 years. And that really is a key requirement. And the reason I say that is that it can sometimes overcome weaknesses in other areas, such as a low investment amount. The business also needs to be real and operating, which means that it should not be speculative. So certain types of businesses like stock trading or real estate investment businesses can be difficult to satisfy that requirement. And the other aspect of that requirement is that when the applicant is actually at the consulate interviewing, really the only thing that should be standing in the way of the business actually generating revenue and employing workers is that visa being issued. So the E-2 visa is not a visa you should try to get to come to the US and then look for business opportunities. You really should have those lined up before you're sitting there in that visa interview. I'll add one more, and Kelly, please do. This is really a list of requirements. So let me know if I've overlooked one. But the other important one is that the applicant needs to have the intention to leave at the end of their visa status. The E-2 visa is not a green card. It does not directly lead to a green card. So it is what the law refers to as a non-immigrant visa. So that's actually usually quite an easy requirement to satisfy. We would include a signed statement from the applicant that states that at the end of the E-2 visa, they plan to leave the US.
Perfect. No, I think so. I think that covered the majority of them. I think there's one subtopic kind of investment we haven't covered, and that is the source of funds.
Absolutely.
Maybe if you could talk a little bit about, so you're investing money. Where can that money come from?
Absolutely. So another requirement is that the funds that are invested in the business need to have been legitimately and lawfully acquired by the applicant. So fortunately, though, the law is quite broad in terms of where the money can come from. The money that the E-2 investor applicant spends on the business can come from salary that they earn from work. It can come from a gift that really anyone gives them. It can come from a loan, as long as the loan is not secured by the E-2 business or its assets. And so really the spectrum is broad in terms of where the funds can come from. How this requirement usually appears in an application is that we would always include documents that really do walk the government officer through how the person got the money. So you need documentation that shows that. So just as an example, if you got the money you invested into the business through work, we would typically include tax returns that shows that you earned that income. We'd also consider including pay stubs. And we might even include bank statements showing the money coming into your bank account and then actually leaving your personal bank account into the business's bank account. I think we'll talk a bit more about loans and gifts, but those are some complex areas in terms of the source of funds, but similar documentation requirements.
Perfect. Thank you. So a lot of documents that you've discussed, a lot that you kind of need to do to get this visa. Once you do all of this, how long can the E-2 visa be granted for?
So the period of validity for the visa really does depend on what we call reciprocity with the country of nationality. So it is country by country specific. One easy way to find out how long the visa can be issued for is to Google US Department of State reciprocity. And by doing that, you'll find a link to the US Department of State's website. You would click on the country where you are a national, so the passport that you are applying for the visa on. And then you'd be able to see for an E-2 visa how long they'll issue that visa for. So this ranges from a maximum period of time of 5 years to a minimum. I think the shortest period of time is 3 months, I believe. And so that would be largely determined by the passport that you're applying for the visa on. So for example, if you, I believe Bangladesh has a 3-month validity period.
Yeah.
So if you are applying for an E-2 visa on a passport from Bangladesh, let's say that you're applying in Canada, your validity period is going to be limited to 3 months because of your Bangladeshi passport, even if you're applying at the consulate in Toronto. The other factor that could limit the period of time of your visa is in some ways the nature of the business. So if you are applying with a startup, for example, that the consular officer thinks is somewhat speculative. They want to see how it's doing for a year or two, and then they want to revisit it. They might issue the visa for a year or two and ask you to come back to the consulate and then renew it rather than giving you the full validity period.
Perfect. Perfect. So, so now let's switch to, I think, probably the most common question that we get about the E-2 visa, which is how much investment is needed for the E-2 visa. And I know you've talked about kind of $100,000, previously, but we also know that the actual investment amount is going to kind of depend on the type of company. So could you talk a little bit about, how much investment is needed depending on what type of business you're starting?
Absolutely. So the government talks about what they call a proportionality test, and it can be somewhat confusing, but again, the language the government uses is the investment amount needs to be substantial. And so the proportionality test talks about how if you're starting a business that is relatively less expensive to start, they want to see 100% of those funds invested. So to take an example, our firm was started on an E-2 visa. A law firm doesn't require a lot of money. You can start a law firm with a computer, a small office, and get started. So that kind of a business where, let's say the investment amount is, let's say $50,000, the government's going to want to see 100% of that $50,000 invested. In contrast, if you're starting a business that's dependent on manufacturing, an example we like to use is you're developing that new battery for an electric vehicle. That is the kind of business that will probably take several $1 million to invest in to get it started. So what the proportionality test would say is, if you're looking at a large investment amount, it's okay to invest a percentage of that. So let's say the business requires $10 million to get started. The government is okay if you have invested only 5 million, 7 million of that, 50 to 70%, for example, rather than 100%. So that's one aspect of what amount is substantial. The other aspect of it really is the kind of business, but to take a different look at it. When we look at what is a risky case, let's assume we're talking about two types of businesses that are both in the $100,000 range. So we're not talking the multi-million-dollar company. So we're talking 100,000 or so. So the government's going to want to see 100%. The type of business is still relevant there, because what you want to show the government is that you really have invested enough in the business to get it operational, real and operating. So what we would include in our applications is a detailed spreadsheet that lists every single item that's been purchased for the business. And when the officer looks at that, they'll be able to see that with the amount invested in the business, everything's been bought, so that once this person gets the visa, they can come to the US and hit the ground running. And the last thing I'll say about the investment amount is that the government, one of the very common questions that we get is, in business, you don't typically want to put everything on the line at the start. You want to put some on the line, and then you want to start generating revenue and reinvesting that. And that's what's efficient. That's what a good business practice is. Unfortunately, the government does not think about it that way. The government really does use the investment amount almost as a test to gauge the applicant's commitment. And a consular officer is oftentimes going to look at that overall amount and say, wow, you've invested 150,000, you are clearly committed to this business. That's how they think about it. So those are kind of the ways that the investment amount factors into an application. But in the end, I would say what we would usually recommend to clients is, given the nature of the business, invest as much as you can that is reasonable for the business. So don't just waste money, but if you can spend more on marketing, if you can spend more on paying your office lease in advance, do that. And if you've reached a point where you can't invest more, I think that's the point where you really want to have a conversation with an immigration lawyer and think about what other aspects of the application can you strengthen.
Perfect. And I think that kind of takes us into, I think, another really common question, which are, what are some common E-2 visa expenditures? And also kind of, are all expenditures kind of good? What is considered strong for an E-2 versus, what may kind of be related to your business setup, but not be viewed favorably, by a consular officer.
Right. So I think the starting point for thinking about what a good expenditure is going back to what I was referring to with the investment schedule. Most good expenditures would be things that are necessary for the business to run. So, and that depends on the type of business. So if you are starting a coffee roaster, good expenditures would be getting a space, getting an office space, marketing the business, buying equipment to roast the coffee beans, paying for inventory, buying the actual coffee beans. Always a great expense is employees. So if you can hire an employee, a W-2 employee, or even an independent contractor to do work, that is almost always going to be a worthwhile expenditure. So the scope of good expenditures, I think, is quite broad, and really is anything that the business needs to be real and operating. In terms of weak expenditures, there are certain categories of things that when an officer looks at them, they're more likely to kind of question why the applicant would include something like that, which could cast doubt on the application as a whole. So things we would generally not include would be travel expenses. So for example, if they come to the US to search for businesses to purchase or to start, we would not include the flight. We would not include hotel expenses. Most educational expenses, so certainly advanced degrees almost always would be excluded. Any training programs, there are some exceptions to that. So if you do have those, don't automatically discard them. But by and large, we would not include educational expenses as valid business expenditures. These are considered things that really are for your own development that happen before you decide to start the business. And the other, I'm trying to remember, there is another category that I had in my head until about 20 seconds ago. Vehicles. So oftentimes applicants will want to include a car or a truck. And that can be good if the business clearly requires it. So for example, I had a client who was focused on renovating homes, doing construction. A truck was needed for that to move both employees as well as equipment. Had another case where a vehicle really was not needed. And so had they included it, we ended up not including it, but had they included it, it would have almost certainly raised a question at the consulate about why are you putting a vehicle in the application? Are you trying to pad it in some way to hide something else? Or, so if you're going to include a vehicle, make sure it's needed for the business itself.
Right. And I think something else that, sometimes comes up are payments between related parties, right? So sometimes, we have clients, maybe they have multiple businesses, they need to develop a website. Perhaps they want to pay their company abroad for that website development. And I think we, generally will say that's really not a good use of funds for the E-2, because ultimately for your funds to be committed and at risk in the commercial sense, if they're just being transferred from one company you own to another, I think that's also not going to be viewed very favorably.
Absolutely.
Perfect. So let's switch gears a bit. So another thing that really comes up, I think, quite frequently is people are interested in purchasing a business from someone they know, perhaps a relative. Maybe they want to buy 50% of the business or purchase, the business outright. Can you do that? Is that permitted?
Yeah, so it's closely related to what you were just talking about, Kelly. So the answer is yes, you can buy a business from a relative. There's no prohibition on that. But going into that, you should do everything, primarily meaning document everything to show to the government that it is a legitimate purchase. And I think there are a couple aspects to that. First of all, you want to be able to show the government that you're paying an amount for the business that really is a fair market value. You're not paying a discounted rate or an overly inflated rate just because of the relationship you have to the seller. That basically, if the seller of the business were going to sell this on the open market, they'd be asking the price that they got for it from you. So as a relative. So one way you could do that is you might consider getting a statement from an accountant that actually looks at the business and attests to the fact that the amount paid is the amount that is the fair amount for the business. Another aspect of it that I would probably encourage is probably to have professionals involved in the transaction. So I think it legitimizes a transaction when there are attorneys and accountants involved, and where you can provide documentation of the transaction showing that lawyers had their eyes on this, that this wasn't just something that happened over a dinner table between two brothers or two sisters, that it really is legitimate. So the other aspect of it that Kelly you were hitting on earlier is the government needs to be convinced that the funds were actually spent. So that can be a very difficult thing to overcome when you're buying a business from a relative. All the things that I said help to overcome that doubt, but in the end, a consular officer can always ask, okay, you paid your sibling for this business. How should I be, persuaded? Why should I be persuaded that these funds did not come back to you? How do I know these funds were actually committed? So keep all documentation showing the transfer of funds and be ready and anticipate that line of questioning.
Perfect. And, so I think our next question is really about, whether you can get a loan or a gift for your investment. I know we talked about it briefly earlier, and we can dig into it more now. One question I think that, has come up is, if you're purchasing a business from a relative, can that relative gift you the money? Will that work? I think that's a common question we get with an easy answer.
Yeah, so very risky. I mean, there are two things there. First of all, is you're buying a business from a relative, and you're also receiving the money to buy the business from a relative. So I would say you're really setting yourself up for a denial in that case. But to take each of those separately, buying a business from a relative is okay. Receiving a gift from a relative is generally okay. But again, when you combine those two, I think you really are setting yourself up for a denial. So if you do have to go forward with that, I think everything I said before is especially important. Bring in third-party professionals to come in, oversee the process, document absolutely everything. But if at all possible, no, I would not use a gift from a relative to purchase a business from the relative, because the question that's going to follow from that is, what of your own funds did you commit to this business? And that gets at the heart of, again, how the government thinks about commitment to the business. They want to see that you have earned or legitimately received the money that you committed to the business, that it was yours to do what you wanted with. You could have spent the money, you could have invested it, but you chose to purchase and commit yourself to this business. And the scenario you described, Kelly, really calls that into question, and I think would be quite hard to overcome.
Perfect. So another question, do you have to have employees before filing the E-2 visa in order to meet that marginality requirement?
So the answer to this is within 5 years, and really by the time you apply for a renewal, you want to be able to show the government that you've employed US workers. And what we would generally recommend is that you should aim to employ at least three full-time equivalent US workers within 5 years of operations. 5 years, because that's usually when you need to apply to renew the visa. And so but to go back to your question, you do not need employees when you apply for the visa, when you initially apply for it. We actually usually work with clients who are applying based on business plans and are applying based on projections, hiring projections, financial projections. And so what they are telling the government is I have these projections that show that I will be employing US workers, and that is sufficient to get the visa, as long as you, again, can project at least 3 full-time equivalent workers within 5 years. And Kelly, as I was sharing that answer, I realized that I missed something I did want to add to one of your earlier questions, which was how long the visa lasts for. I did just quickly want to say that there is the visa validity period, and then there's the status that you get each time you enter the US. So I use the example of Bangladesh, 3 months of visa validity. Each time someone enters the US on an E-2 visa, they receive 2 years of status, E-2 status in the US. And that is the same whether they're entering on that 3-month visa or if they're entering on a 5-year visa. So each time you enter the US on that E-2 visa, you get 2 years of status, even if it's theoretically, even if it's on the last day of that visa. So I did want to quickly add that to the length of status. Kelly, I know I did want to share questions with you as well, if you'd like to reverse our roles real quick.
Absolutely, absolutely.
Sure, and I know a few questions have come in. I think we'll probably touch on those at the end. I think that's probably best. So Kelly, I'll share a few questions with you. I'm curious. We've talked about weaker cases, and our firm does specialize in what we consider weaker, riskier E-2 cases. What have you found are some strategies to effectively deal with those weaker cases?
Sure. So I think, when we're talking about kind of weaker cases, we're generally talking about cases where the investment amount is lower. So we're talking about kind of under $200,000, under $200,000 or under $100,000, really, really low. I think that the best way to deal with that is to make sure that all other aspects of the case are as strong as possible. So every other requirement, real and operating, marginality, you really want to make sure that those are, have a lot of strong aspects to them. So for marginality and real and operating, perhaps you are able to show client contracts or letters of intent, anything that shows there's a real market interest for your company. It's also good to have, particularly for startups, a strong, 5-year business plan that is going to explain, how you're going to make your money, how you're going to market your products, the realistic financial plan that you have, the realistic 5-year hiring plan that you have. If you're able to, perhaps hire an employee, even if it's kind of a part-time employee, perhaps who's in the US doing some, office manager aspects for you or startup activities. Another thing you can do if you have that lower investment amount is you can get kind of some market reports or industry reports that speak to what are the startup costs for your particular type of business that show that you have spent at 100% or even in excess of 100%. There's many kind of business publications, Entrepreneur Magazine comes to mind, that will publish these lists of different types of startups and what it takes to get those started. And if you've spent in excess of that, I think that's a good way to really show the consulate that you've spent, everything, that it should be a viable case.
Perfect. And two of the general areas where we have to navigate risky or relatively weaker cases are oftentimes consulting businesses and real estate businesses. So a few questions along those lines. First, with respect to consulting businesses, what are some common challenges you've seen that are specific to those cases, and how do you overcome those? And I'm sure a lot of what you already said will come into play there, but with respect to what's unique to consulting businesses.
Sure. So I think a challenge on the client side is how to invest enough money. It's very common that we have people come to us, they want to start a consulting business, and they say, I don't need to spend money. I have a computer, I'm an expert. That's all I need. I have nothing to spend money on. So I think on the client side, that's a really big challenge for consulting businesses, is working with the client to help them understand what they can spend money on. And as you mentioned earlier, Dustin, not just throwing money away, but really being smart. How are you spending money in a way that is going to help your company down the line? So a lot of the things we've talked about, office space, marketing expenditures, perhaps you are planning to hire 3 employees in your second year and you wouldn't purchase that computer equipment for them up front, but you purchase it because you need to make those expenditures for the E-2, and they're good, solid, tangible expenditures. So I think client side, that's a challenge. I think, when you're looking at the consular officers, what they're going to scrutinize for consulting businesses is the concern that someone's going to come in and be a solo consultant. That's really always their concern, is that someone wants to get this, 2, 3, 5-year visa, and they're just going to come in and work by themselves. And that's really not what the E-2 visa is for. It is for somebody who's going to create a business that's going to sustain more than just the investor and their family. So I think a good way to, kind of deal with that is to have an employee when you file, if you can, if at all possible, for a consulting business, particularly if you have been a consultant in your own home country for a long time and you've not hired anyone. I think it's really key to show that you actually, in good faith, are going to hire an employee. We certainly have processed them successfully with just the business plan. But I think, having the employee can be a really helpful thing for the consulting business. The other really important thing for consulting businesses is to try to have some letter of intent, some contract signed up. There's lots and lots of consultants. You really want to show that there's actual market interest in your products and that you yourself are able to develop this type of business, that there's actual interest in your services. And I think we have successfully processed consulting E-2s where they don't have employees and they don't have letters of intent. But we've had to, I think in those cases, you really need to have an extremely strong business plan. You have to have a really attractive website. You need to make your service offering really clear. And having those letters of intent, those client contracts, and that employee are really going to help your case.
Perfect. And Real estate cases, again, are kind of notorious in terms of how challenging they are as E-2 visa cases. Can you say a little bit about why they tend to be challenging and how to overcome those obstacles?
Sure. So I think that they're challenging partly because a very common misconception about the E2 is that you can just purchase a property, put it into an LLC, and that can be your investment. There's even on many consulate websites, kind of in the FAQs for E2s, they say this is not acceptable. So I think this is a really common thing that happens. People, lots of Canadian clients perhaps have properties in Florida. They will come and say, hey, I purchased a property. Can this be my investment? So it can't. Just owning a property, it's not a real and operating enterprise. And I think that's really the key issue with real estate is it going to be an active enterprise that's going to, hire U.S. workers and actually, take in revenue and not just be passive real estate income? Another thing about real estate is it's a really regulated industry. So depending on what you're doing in real estate, you may need some licenses, and those licenses can sometimes be hard to get if you don't already have a social security number, if you don't already have, certain things in the U.S. So when you're thinking about doing a real estate based case, you want to always keep that in mind. So if, let's say, you're really interested in house flipping, most of the time, house flipping just by itself is not going to be active enough unless you're doing it on a very large scale. So we have clients that were, developing 30, 40, 50 houses. That type of portfolio, especially if there's kind of other things that you're doing, you're doing some property management, renovation, that can be a viable E2 enterprise, but it has to be on that large scale. Also very common, clients will come to us and say, I have a couple Airbnb properties. Is that going to be sufficient? Generally, again, the answer is no. If you're going to do that, if you want to do property management with properties you own or others, it should be on a much larger scale. So if you have those two properties and you're interested in developing a property management company that's going to manage a much larger portfolio, that could potentially work, but not just, a couple properties that you own and you take in the rental income. Some real estate things that we've done that have worked: a real estate brokerage firm, property management company, renovation and construction. And then, as we talked about, house flipping on that large scale. You may also combine some aspects of that. We've had clients perhaps that they were in kind of construction and renovation, but on the side, they also wanted to do house flipping. And that was fine. That was included in their business plan. But it wasn't the main service offering of their company. And they were able to show that they were able to hire lots of workers for that other active line of business.
Great. And Kelly, you at the end of your response there, I think you touched on a really key aspect of E-2 visas. And this is a question that comes up quite a bit: is someone comes to us and they have kind of two business focuses. In your example, one was house flipping, which could be problematic, but fortunately they had another aspect of the business that was viable and that they were interested in, such as renovating homes or property management, something like that. Could you say a little bit about how applicants can go about structuring a case where it does have two focuses, maybe one not so viable as an E2 business and the other viable?
Sure, absolutely. So I think that a key thing is that when you're going to the consulate and presenting your business, what you present is what they're approving, right? So if you're going in and you say my business is going to be kind of renovations, and then suddenly you want to start doing mobile app development, they didn't approve that, you can't just start doing that, without some type of approval. But one thing you can do when you have a plan in your mind and you have kind of disparate business ideas, perhaps, is you can put that all into your business plan. So let's say that, you're planning to start your business, you're investing $100,000 into your home renovation business, but in the future, you want to also, do some house flipping, or maybe even something different than that. Maybe in the future, you want to do mobile app development. That can all be contemplated in your business plan. And there should be an explanation of what you plan to do. And if that is reviewed and approved by the officer, that gives you that ability to expand into those lines of business in the future. One thing you do want to be careful about, though, is that when you go to the consulate, you're saying you've spent everything necessary to get this business up and running. So for these more kind of attenuated ideas for the future, you can add those in. But if they're really, really different and they're really different and would require lots of startup capital, you do run the risk that the officer might say to you, well, what have you invested to get that up and running? So, you want to just work with your immigration attorney to draft a business plan that makes sense. And also just know that if you do have kind of those expansion ideas for the future, it's a good idea to contemplate those in the initial business plan, to kind of give yourself that freedom to expand in the future.
Perfect. So we've talked a little about consulting, real estate. Are there any other especially risky E2 areas that you've come across?
So I think another risky area is equity trading companies, kind of for very similar reasons for real estate, in that people kind of are doing trading for themselves, perhaps for their families, maybe a couple of friends, and they think that they can kind of use that as a business. And so the idea is it real and operating? Is it active enough? So you really want to address those same concerns as with real estate to show that it will be active. It's not just personal trading. You need to have a viable business plan that shows you're going to be seeking out clients that are separate from just, you and your friends and family. You want to show you'll be able to hire employees. You want to show letters of intent or contracts with potential clients that are interested. And this is also another area that's very heavily regulated. So you want to have the appropriate licenses. Or if there's kind of some larger structure, often with investment firms, there's kind of multiple entities. You want to make sure that you have the licenses in place and that the structure is in place, that you can explain it to the officer so they're comfortable that you actually have the permission to run this type of company.
Perfect. So you've touched on in the session so far, you've already touched on reasons why E2 visas are denied. We talked a little bit about low investment amount, also speculative businesses, questions about whether it would be real and operating. What are some other common reasons for E2 visas being denied?
Sure. So I'd say, unfortunately, one common reason, another common reason can be kind of your location, your venue. Not every consulate is as sophisticated in its knowledge of E2s. There are some consulates that just don't process them as frequently, and that can sometimes be a benefit, but sometimes not. We've had clients go to consulates that aren't familiar with the E2, where the officer said, well, you have to have employees before you can even apply. And that officer actually had to go back and talk to a senior officer before they approved the visa. But so when you run into those types of venues where people aren't as familiar with the E2, sometimes that can be a bit of an uphill battle. Additionally, you sometimes have consulates that are very familiar with E2s, and there's consular officer turnover over the years, and they may take a different approach to E2s, or certain consulates may sometimes decide that anything under a certain very high investment amount isn't going to work. And so it is important to kind of speak to your attorney, who will have a good sense of kind of where the various consulates are at particular times, so you can figure out, okay, is there, do I have an option to go to another venue? So for example, there's many pros and cons to filing from within the United States with USCIS, but one pro is they are more open to low investment amounts. So that's just something you want to discuss, with your attorney to figure out if you are, a national of a country where the consulate's not very friendly towards E2s, perhaps there might be some other option for you. Another kind of reason for denial, can be that if they're concerned that the business is not going to create jobs for U.S. workers. So we talked about that with, consultancies. We talked about that, earlier. Additionally, people who have run their own company in their home country and have never hired employees. And, if you have the funds to do so, a really simple way to address this concern is just to have an employee, before you file. Or if you're purchasing a business, make sure you're purchasing a business that has employees, and make sure that it's clear, that you plan to continue those employment relationships. So I think that can be a really, an easier way to address that. Sometimes people have issues with the adjudicating officer. Unfortunately, the officer has complete discretion over whether to grant or deny your visa. I think it's really the exception. Most of our clients have, good experiences, or the officers are quite professional, but consular officers are people, and, you always could catch one on a bad day, or one who's just made up their mind about your particular line of business. Something to keep in mind is that if you do reapply, let's say you're denied and you reapply, most consulates will make the effort to give you a new officer. It's not a guarantee, it's not required, but it is something that most consulates try to do. So it's a good thing to keep in mind, particularly if you feel that you got an officer who is just having a bad day, or you feel that your denial was really unfair, based on the regulations. And then I think finally, last one is some of them, perhaps you go in and you just don't meet the requirements at the time of filing. Let's say your company is, you own your company, in thirds with 2 U.S. citizen business partners. You will not qualify because your business is not at least 50% owned by treaty country nationals. So those types of issues also may be a reason for denial.
Perfect. So to switch gears just a little bit, you used the example before about a real estate business that got interested in a mobile app, and how the mobile app was not a part of the initial business plan. Can the E-2 business change after it started? And if so, what's the process what are the requirements there? Do you have to let the government know? What does that look like?
Sure. So you do. And it really will boil down to, is your change what's considered a substantive change, or is it non-substantive? So let's say, for example, you're a wedding photographer and you decide you want to add, a wedding blog that's marketing, photography products. That's really kind of, I think, could be described as a real natural outgrowth of your business, and probably not going to be considered a substantive change that needs to be reported. But let's say you're a wedding photographer and now you want to completely shut down that line of business and you want to open a restaurant. That type of change does have to be approved before you can proceed. And there's a couple ways to do it. So one is you can contact the consulate where you were approved and ask for their feedback. Do they want you to send them new documents, and they'll, change the approval? Or if you're in the United States, you can submit a petition to U.S. Citizenship and Immigration Services to either ask them, is this change substantial? Or if it's really clear that it's a substantial change, so, wedding photographer to restaurant, pretty clear that's substantial, you're going to be filing an amendment with USCIS to say, I'm amending my, my E-2, and I'm now doing this new line of business. And it's really key. You have to get that approval first before you start the new substantive change line of business. If you don't, you will be considered to kind of be out of status. So just the fact that you have a 5-year visa, sometimes we have clients come to us after the fact where perhaps they had a 5-year visa, but they sold a business and they bought a new one within that time. And that unfortunately puts them in a really bad situation because they did need to get an approval before they went through those steps. And the fact that their visa is, facially valid does not mean it's still valid if they have completely changed their business line and not reported it to the government and gotten an approval first.
Perfect. Thank you, Kelly. So we have about 10 minutes left, and I know a few questions have come in. Kelly, I don't know if you saw any that you wanted to respond to in particular. I'm happy to just dive into the first one that came in.
Sure, I think the yoga studio one, I've done a few of those, so I can certainly speak to that as well. So maybe if you could get started with the first one.
Yeah. So the question is, I'm a digital freelancer. I'd like to transform my business model into a publicity agency, move to Kentucky, and eventually hire people. Is it a good first step to open an LLC in Delaware? I ask because I already have clients in the US that I attend to from my country. So it's a good question. And I think what it's getting at is kind of what is the process, and what is kind of step one, step two. If you are outside of the US, and it sounds like that is a situation here, from an immigration perspective, there is no prohibition on starting a business in the US, selling your products and services to people in the US. Again, that's assuming you're outside the US. So in response to this question, it would be perfectly fine to set up a business in the US. It does not have to be in Delaware. Delaware is probably the most popular state in which to form a company, but it really can be in any state, whichever makes the most sense. And we are immigration lawyers, so talk with a business lawyer who can advise you on which state is ideal if you have questions around that. But from our perspective, our clients really do start their businesses in a variety of states. So we're not aware of the particular state really making a difference from an immigration perspective. And yeah, once that business is started, that is the business, then the entity, the LLC, that you would then form a business bank account for, begin transferring funds into, and then spending those funds on marketing, on equipment like an office, like office chairs, furniture, an actual physical space, maybe hiring a worker or a freelancer. So that's in general what the process would look like here. I think that was the thrust of the question, but please do feel free to write in if I've missed any other aspects of the question. So yeah,
so
go ahead.
one other thing I'd just say, Dustin, is, while I think it's completely correct, you want to speak to a business attorney to figure out where you want to incorporate. One thing we do all, recommend to our clients is you might want to think about incorporating in the state where you plan to do the most business. The reason being that if you file for an LLC in Delaware and then you have to file an amendment, a certificate to operate to do business in Kentucky, if that's where most of your business will be, or that's where your corporate office will be, you're now subject to compliance in 2 states. So that's just something to keep in mind. We do have many clients that initially incorporate in Delaware, and that may be the right choice for you. But I think it's not kind of every business should incorporate in Delaware. I think it's much more, sometimes it can make more sense to incorporate where you plan to do most of your business, so that you're not subject to kind of 2 state requirements, 2 annual reports, 2 fees, things like that. So that's kind of something to keep in mind as well.
Perfect. And so Kelly, I think the next question that came up is this one about how much would be needed in terms of an investment amount to start a yoga studio?
Right. So we've done a few of these, and I'd say that the ones that we've done are kind of somewhere between the $100,000 to $200,000 mark. And I think a yoga studio, it's really going to depend on whether you're purchasing an existing business, or you're starting up your own company. But that being said, ultimately, it's a business that has a lot of clear startup expenses, right? So you have to rent your studio space. You have to pay to have your studio space set up. Perhaps you need some business licenses, to operate. You need to have your LLC or your corporation. But somewhere around, I'd say that 100,000 to 200,000 mark is generally what we've seen. Even when people are kind of purchasing the assets of a yoga studio, you need a website, and there's lots of very tangible expenditures for that. So I think it can be a quite good E-2 option. One caveat is yoga studios sometimes will operate on a contractor basis, where all their yoga teachers are independent contractors, and that really is not ideal for an E-2. You really do, if you're purchasing a yoga studio, you want to kind of be either speaking to the previous owners to figure out what was their model. And if it was an independent contractor model, you should have a business plan that shows how you are actually going to hire full-time W-2 employees. You can still have some independent contractors, but you should at least have, 3 to 4, W-2 employees.
Perfect. So I see a question here that I personally find interesting, which is, what options do E-2 visa holders have when their company is acquired if their nationality is not the same as that of the acquiring company? So we talked before about how one of the threshold requirements, and I say threshold because if you don't meet this requirement, you don't get to move forward at all. It's not like a low investment amount where they'll consider other aspects of the application, is that you have to own at least 50% of the E-2 business. So you as the individual who has the nationality of the E2 treaty country always have to have at least 50% of the business to be eligible for an E2 investor visa. So the moment at which your ownership drops below 50%, you become ineligible. And if you have E2 employees, they would also become ineligible. So it's quite a drastic change. So I would always recommend, if you're thinking about selling equity and you are an E2 investor, it's worthwhile to talk with a lawyer about that, just to make sure you're navigating it correctly before you've made any commitments. I will tell you, I have been contacted, our firm has been contacted by individuals who are in the US on E2 visas who have already sold part of their company, and they now have to fix a big mess because they didn't realize that their employees have now lost their status and might be barred from re-entering the US as a result. So this can be a big issue. Now, that being said, as long as you're maintaining 50%, the other 50% ownership isn't as material, assuming that they are not also on an E2 visa. But it's possible for you to have 50% as a national of a treaty country, and the other 50% to be owned by, say, a US citizen or a permanent resident or someone from another country. That is okay. So if you're looking at selling that other equity, again, make sure you have your 50%, but there is some flexibility there in terms of the remaining percentage. I would still say talk with an immigration attorney, but in theory, that is how it would work. Kelly, I don't know if you saw other questions that I know Flo had a few here. They may be connected to each other. Did you want to try diving into those?
Sure, absolutely. So, so the first question here, about a partnership with two applicants, estimated total investment of 300,000. Is it reasonable to keep 100,000 as working capital? So I think that it really depends on what type of business you're starting ultimately. I think I will say that very large working capital amounts are not viewed that favorably. Generally we would like to have the expenditures be higher if possible than the working capital, although that's not always the case. But it used to be that there was language, in the Foreign Affairs Manual that said a reasonable amount of working capital could be counted as investment. That language is now gone. They took that language away. So that indicates they're really not viewing working capital that favorably. That being said, I think from just a business common sense perspective, businesses need capital and they need operating capital. They need working capital to operate. So I think we still do include it because I think it does make sense from just the narrative of what the business needs. But, and 100,000, I think that the general amount is fine, but it's really going to depend on what are your expenditures and what type of business are you starting. And I think that you could be in a position where they may not want to see, a huge amount of working capital. Just going down the list here, how to deal with wait times from the embassies when rent needs to be paid for a physical location. So unfortunately, delays are ongoing. It is quite difficult. I think that, ultimately you can, try if possible to have some flexibility built into your lease. But it may be the case that if you are applying and you know that your consulate has appointments several months out, that you try to obtain space for a future date, so that you're not paying. So maybe you prepay for 6 months, but in the future, so that you're not just kind of wasting money. But it is a challenge. There's kind of no perfect answer for it. It will kind of depend on what your business needs, and what your landlord is willing to negotiate in your lease. And Dustin, I don't know if you've seen the last one, if you have any interest. I don't know that there's a perfect answer to that. I think it's very situation dependent.
So let's see. It's a partnership, two applicants from the same treaty country, assuming they own it 50-50, one legally in the US on an F1, another partner outside of the US. How to time visa application, status change. And what happens if one is accepted or denied. So let's work with that second part. It could be the case that only one of the two co-investors is approved. I think it's important that in the application, it's clear why both individuals have an active role at the company. Remember that an E2 visa is not for passive investors. You really do need to develop and direct the business. So show how each of the two applicants really are critical to to developing and directing the business. Maybe one's a CFO, maybe one's a CEO, something along those lines. In terms of timing, I think I'd have to know more about the specifics, but in general, my thought would be, given consular delays, usually it's not worthwhile to delay an application at a consulate because you just don't know when they're going to call you in for an interview. It could be a year from now. So my general recommendation would be to get the application into the consulate as soon as your materials are ready. Assuming the LLC is created, you've invested money and you have documentation, that the business is real and operating, and all other aspects of the application, I would say submit the application to the consulate and get in that line so that you can get in there for an interview. In terms of the F1, it's certainly possible to change status. There may be a reason to wait to change status if you're still in your program. So that to my mind would control when you'd want to apply. But just as a general response, you can certainly change status from F1 to E2. You would need to be thoughtful about setting up the business while in the US so that you don't commit any violations of your status by working without authorization. So that could mean working with your designated school official. It could mean hiring someone to run the business so that you do not appear to be running the business actively while you're in the US in F1 status. But otherwise, in terms of timing, Kelly, let me know if you have any sense of timing constraints, but I would just say when it makes sense and your F1, is coming to an end and you're ready to jump into the E2 role.
Yeah, I agree with that. I think that makes sense.
And I think the only thing I'd add, and Kelly, we didn't talk much about the difference between applying to USCIS versus a consulate, but one thing that I do think is important just to put out there is USCIS, they don't give a visa, so you can't travel based on a USCIS approval of status. But one of the benefits of applying to USCIS is they do have the option of premium processing, which will give you a response within 2 weeks. So if you're in the US and you really want to get started on an E2 business, that could be a great option.
All right, I think that's all the questions that we have. So let's see, perfect. I think just one last thank you. So thank you to everyone for your great questions. Thank you, Dustin, for sharing your knowledge, and I hope everyone has a wonderful day.
Thanks so much, Kelly. Really a pleasure.